we're looking at administrative structure of immigration law, and it all sits within the Department of Homeland Security. I guess this all happened after 9/11, ways to obtain lawful immigration status. And within immigration law, there are 3 ways to obtain status: through family members, employers, humanitarian relief. Criminal law is, again, done state to state. So each of the states have different they will have different definitions of what constitutes crimes.
Welcome, and thank you for joining us for another Justia webinar. My name is Nina, and I'll be the moderator for today. Now, to kick things off, I want to go ahead and introduce our speaker, Esther Lim. Esther joined Her Justice in 2008. She is currently responsible for collaborating with a team of staff attorneys, pro bono coordinators, and volunteer attorneys to provide advice, legal advocacy services, and free legal representation to women living in poverty in New York City in the areas of matrimonial, family law, and immigration claims pursuant to the Violence Against Women Act. Specifically, Esther trains and mentors approximately 90 volunteer attorneys at more than 20 law firms regarding immigration cases with the United States Citizenship and Immigration Service, litigation strategy, and changes in law and legal procedures. Esther is admitted to practice in New York, Virginia, and California. The webinar presentation that you're about to watch will be approximately an hour and a half, and Esther will be taking questions from the audience, time permitting, at the end of the webinar. So if you have any questions that come up, please feel free to submit them by clicking the Q&A button in the control panel at the bottom of your screen so we can see them there. And now, without further ado, here is Esther to discuss preparing successful U Nonimmigrant petitions for victims of a crime.
My name is Esther Lim. I am the Immigration Practice Director here at Her Justice, and I've been at Her Justice for about 17 years. Thank you so much for joining me today for this discussion and this training. We are going to be talking, I'm going to be talking a lot. It's about 90 minutes here. It's a lot of information. It's pretty dense. I speak rather quickly. If you need me to repeat something, please just let Nina know in the chat to ask me to repeat it. I will. And we will just cover a lot of material today. So please bear with me. There is no break that is embedded or is set up into the programming or in the agenda. So if you need to take a break, please take a break. But we will continue to keep going. Okay, so just so you know that, and we are here, it's about 90 minutes long. There will be a Q&A at the end, but and without further ado, let me just move on. So here's a couple of housekeeping things actually before we start, is that what do you call it? There's some interchangeable terms here. It's going to be the U visa, U Nonimmigrant Status, victim, survivor, things like those 2 things are going to be interchangeable. Again, I'm going to talk about U visa, U Nonimmigrant Status. A lot of people refer to it, this process as a U visa. Some people, the more technical term is U Nonimmigrant Status. And when we talk about our crime victims, and some people prefer survivors. So again, those terms are going to be interchangeable, just so you know. Those are a couple other housekeeping things. And our learning objectives for today, as you can see, I'm going to talk a little bit about Her Justice, what we do here in New York City, and then we're going to go into a lot of the overview of immigration law, very small overview of immigration law, actually. And then we'll talk about the U Nonimmigrant Status, eligibility for it, nuts and bolts of filing it, the timeline for case processing, best practices. And so hopefully by the end of this training, you will have the toolkit. You'll be, tools to be able to file for a U Nonimmigrant Status for your client. And again, Her Justice, what we are, and this is our mission. We are a pro bono first organization here in New York City. We are a legal services organization, but we work with mainly law firms and associates at those law firms to file family law petitions or family court petitions, matrimonial petitions, as well as immigration petitions for low-income women who live in the 5 boroughs of New York City. Again, we are a pro bono first organization. I do a lot of CLEs. I work with a lot of associates as they are filing these petitions for clients. They aren't experts in immigration law. I don't know how many of you in the audience are experts in immigration law, but again, we work with a lot of folks who are not, and we train them to be able to successfully, hopefully successfully file these applications with the United States Citizenship and Immigration Service, which is USCIS. Okay. And then I'm gonna now turn over to the immigration law overview. Immigration law is dense. It's very expansive. There's so many different facets of it. And again, I'm not going to give you the whole breadth of it. It's like a whole semester's worth of classes in law school. So right now, I'm just going to give you a very, very short immigration law overview. The authority here that we are looking at comes from these statutes, right? The Immigration Nationality Act, that is going to be where you're going to see your laws. And then there's also the federal regulations. Title 8, 8 CFR is also where you're going to see a lot of these statutes. Then we have BIA decisions, which is the Board of Immigration Appeals and Administrative Appeals Office. And then we also have federal court decisions and Department of Homeland Security memoranda. These are the bodies of law and policy that you may hear referenced in the forms and manuals. And again, immigration law relies heavily on agency decisions from the USCIS, which is the United States Citizenship and Immigration Service, and the BIA and the AAO. Okay. Any questions on that? Again, this is just where the legal authority comes from. And when you're looking at structure, we're looking at administrative structure of immigration law, and it all sits within the Department of Homeland Security. I guess this all happened after 9/11, where they decided it's all going to be under the Department of Homeland Security, and it's split up into 3 different sections. The Customs and Border Protection, these are the folks at the border. These are the folks that you're showing your passport to, your visa to, when you're entering the United States. See, there's people that may be, the point of entry or at a border, the southern border, the northern border, that's where you're seeing it. When you're coming in airports, again, this is Customs and Border Protection, or the folks that you are going to be interacting with. I'm going to get to the middle section in a minute, but then the third one is the Immigration and Customs Enforcement, ICE, as we know it. And ICE has been in the news a lot lately. CBP is Customs and Border Protection. They've also been in the news a lot lately because they are the ones right now enforcing the immigration laws and or removability of folks. They're detaining people. They are actually deporting folks. So those are the 2 arms that really have that enforcement angle of actually making people leave and or detaining them until they are heard in court. And then we live right here in the U Nonimmigrant Status stage at this point. Your clients are going to live in this section, the Citizenship and Immigration Service. And USCIS, they're the adjudicative arm of Department of Homeland Security, where they're going to look at the petitions. You're filing affirmative applications to USCIS. So your U visa petition will be going to USCIS. They're going to look at it. They're going to adjudicate it. They're going to say, okay, your client is good or bad. Like they meet all the criteria and they should be granted their U visa or U Nonimmigrant status. So again, in the beginning parts of all of this, unless there is a denial or enforcement issue, your clients and what you are filing is with the and who you are dealing with are the United States Citizenship and Immigration Service.
So we do have a question. The question is, does a federal circuit decision supersede an administrative decision or vice versa?
Yes, the federal circuit decision does supersede the administrative decision. It takes a lot to get up to the federal circuit decisions, but sometimes we do rely on that. The only thing with the federal circuit decisions is that it would only apply in those circuits. So that's where when we argue or we appeal, we may say, well, in the 7th circuit, they said this. And maybe the Second Circuit would agree with it, maybe they won't. So again, the administrative decision may happen, and then the circuit might overrule that. However, that doesn't mean that a different circuit would also agree with that. Does that make sense?
Yes, thank you, Esther.
Okay. Okay, so moving on from here. Does anybody have any questions on just the basic structure of immigration law, the structure of it at all? Okay, because again, this is very technical, but just know that who you will be dealing with is the Citizenship and Immigration Service. And ways to obtain lawful immigration service. And within immigration law, there are 3 ways to obtain status: through family members, employers, humanitarian relief, that's where we are, and actually there's 4 ways. It's winning the lottery. It's a visa lottery, it's called. So again, 4 ways of actually getting lawful immigration status. Lawful immigration status, not meaning that you're here on a temporary visa, but that at some point you may have a path to a green card or permanent residency. And so again, you have family members can apply for you. It's typically a United States citizen or lawful permanent resident spouse or parent will file for you. You can also, if you're a US citizen, you can file for your siblings. And then employers, obviously, when you have employers might say, I need this person to work in my company or in my factory, whatever it is. This specific person has to do it. And the employer can sponsor an individual as well. And then we have the humanitarian-based relief, which is where the U Nonimmigrant Status sits. And you're looking at survivors of trauma, survivors of violence, asylees, refugees. This is where when we say humanitarian-based immigration relief, that's what those are the types of cases that we're looking at. And then there's something, like I said, there's a visa lottery. It's the US government allows up to 55,000 immigrants to enter the United States from countries where we do not have a lot of people from. So for example, say that they say, oh, you know what, we don't have very many Norwegians here. So we want some Norwegians, and they might give, and a person from Norway applies under the visa lottery and you can get that. It is called the visa lottery because it's by chance, and it's very difficult to obtain a visa through this process, but it does happen. And I do know of a few folks that have gotten it this way. Most of them are from Western Europe, etc. But that's what the visa lottery is. For our purposes, again, we are looking at the humanitarian. We're sitting here in the humanitarian part of the, where somebody can get obtaining the lawful immigrant status. And so this is where, if you look at this line here, there's a non-immigrant, adjustment of status, immigrant, and then US citizen. So this is kind of the path a lot of people take to get their citizenship unless they were born here. And so you're gonna many people may enter as a non-immigrant. They may come in. A non-immigrant means somebody who's here temporarily. There is no idea, or they're not going to be here permanently. They're not here. They don't have a green card, right? So they don't have permanent residence here. So your non-immigrants are going to be your tourists, your students, people on temporary work visas, like UN workers, government of like diplomats from other countries are also in this category. And then you have your humanitarian-based non-immigrants, your U visa holders, your T visa holders, and again, others with limited amounts of stay. And then we also have is a non-immigrant or undocumented people who may have fallen out of status, right? You may have had a visa, now you don't have a visa, you're still considered a non-immigrant. And also folks who have just come over the border. You walked over the border, you came in, you're undocumented, and therefore you are a non-immigrant. And then to get from non-immigrant to immigrant, you have to do a process called adjustment of status. It's called adjustment of status because you are adjusting your status from being a non-immigrant to being an immigrant. An immigrant means you have lawful permanent resident status in the United States, a green card holder. Somebody who is the US government acknowledges is here permanently. You're here to live here. You're gonna pay taxes. You can travel in and out of the country of the United States without any restrictions. The only thing you cannot do is vote, and you cannot sit on a jury. So those are the two things that an immigrant cannot do that a US citizen is afforded the right and privilege to do, which is, again, to vote and to sit on a jury is the right of a US citizen. And so you go from non-immigrant to immigrant to citizen. And when you're a citizen, you are either born here or you could naturalize, right? So if you're born here, it's birthright citizenship. It's in the news a lot these days, but again, birthright citizenship, and as part of the Constitution, you're born in the soil, on US soil, then you are a US citizen. But again, folks can naturalize from being an immigrant to being a US citizen. So you take the test, you take a civic exam, you apply for citizenship. Many people in this country are naturalized US citizens.
And Esther, we do have a question from the audience. This person asks, how does the individual's criminal history impact their eligibility prior to applying and after applying?
Good question. We're going to get to all of that because depending on what kind of form you're applying for, what kind of immigration remedy you may have, the criminal impact is greater or less. So again, there's waivers for some and there's no waivers in other cases. So I'm going to get into that pretty in depth a little later in the presentation, but good question. And if I don't get to it, but I will, please ask that question again. But again, that is the criminal aspects of somebody's criminal history of it has huge impacts on the immigration process for sure. Okay, so that's just your basic overview, and now we're going to go into the overview of the U Nonimmigrant Status. And first, I'm going to go through the history and purpose of it. The U Nonimmigrant Status is set aside for victims of certain crimes, certain enumerated crimes that's in the statute, who have suffered mental or physical abuse and are helpful to law enforcement or government officials in the investigation or prosecution of this criminal activity. Congress created the U Nonimmigrant Visa with the passage of the Victims of Trafficking and Violence Protection Act in 2000. And then the legislation was intended to strengthen the ability of law enforcement agencies to investigate and prosecute cases of domestic violence, sexual assault, trafficking of people, and other crimes that are similarly situated. And what happened was a lot of people were victims of these certain enumerated crimes, and they weren't coming forward because many different reasons, but one of the biggest reasons was because they were undocumented and they were afraid to come forward. And so Congress enacted this to be able to help law enforcement authorities to investigate that. They were saying, okay, you know what? You come forward and we can prosecute this, but you need to come forward. And so it was more of a benefit, right? It was a law enforcement benefit as well as a benefit for the non-immigrant to be able to basically normalize their immigration status, but also help law enforcement to prosecute these crimes that were being committed against folks. Okay. The thing with the U Nonimmigrant Status is there's a statutory cap. So when Congress passed this, they said, okay, this is a great tool for law enforcement and for non-immigrants as well. But we're going to put a statutory limit of 10,000 U visa approvals in one fiscal year. So from October 1st to September 30th, the following year, that's the fiscal year. That's the federal fiscal year is October 1 to September 30th. And in that time period, there's only 10,000 that can be approved. Okay. And the 10,000 cap only applies to the principal petitioners. I'm going to explain what I mean by principal petitioner versus a derivative petitioner in a little bit. But again, the 10,000 cap applies to the principal petitioner only. Okay, so that is your where it comes from, what the cap is, and again, it resets every October 1. And so 10,000 is given from October to October, and then it resets again. And the pros and cons, though, of the U Nonimmigrant Status. The pros are, again, lawful non-immigrant status can live and work in U.S. and lawfully for a maximum of 4 years. If you are granted the U Nonimmigrant Status, this means that you can stay in the United States for 4 years, a maximum of 4 years, and you can work here for 4 years without any fear of removal or deportation. There's also family reunification. When I just talked to you a little bit second ago about derivative versus principal. So family reunification means that the person who is the principal petitioner can petition for certain family members and reunite with them no matter where this family member lives. So certain family members are usually for, and we're going to go a little bit more in depth about that too, but again, family members are derivative children, children under the age of 21, no matter where they live in the world. They do not have to live in the United States with the principal petitioner. They can be in the home country, but the U Nonimmigrant Status allows the principal petitioner to be able to bring those family members in. Also spouses count, etc. So parents, it depends on the age of the principal. And then it also, another pro is that it's a pathway to adjust from the U Nonimmigrant Status to become an immigrant. You can actually, after the period of 4 years or 3 years, so you get a maximum of 4 years, but after 3 years, you have the ability to actually apply for your green card or your lawful permanent residency. So that is another pro for applying for the U Nonimmigrant Status. And the U Nonimmigrant Status sometimes is the only pathway for many folks to be able to normalize their immigration status, meaning that they can actually become a green card holder, a lawful permanent resident, and then not have that fear of removal or deportation from the United States. Now, what are the bad things? The cons of this, again, of filing for the U Nonimmigrant Status is that there is that statutory cap. There's 10,000 a year. Okay, 10,000 a year, and the law was passed in 2000. Regulations for this actual regulations for the U Nonimmigrant Status actually didn't go into effect for 9 years. They take a long time to actually put out the regulations of how it's going to work, the mechanics of it, and everything. And so the law passes in 2000 and 2009. The regulations go into effect, and people start applying for it. And I think up until 2012, they were hitting that 10,000 cap, maybe at 12,000. And then since then, I'm going to tell you, there's over 340,000 petitions in a waiting list. And this is both principals and derivatives. Okay, so again, I think for the principal petitioners, there's about 200,000+ petitions on this waiting list that are just pending right now. So huge backlog. And the statutory cap still holds. 10,000 a year is approved. So 10,000 are approved a year. So what does this mean? I've been doing this a very, very long time. And right now we are looking at petitions that were filed in 2016 and early 2017, late 2016, early 2017. Petitions are being approved. I have a client right now. I'm waiting for a January 2017 filing to be approved. I have no word about it. We don't know, and she's still on a pending wait list. We're going to talk about what your clients are able to get while they're on this pending wait list and in a little bit. But this is one of the biggest cons, I guess, negatives about the U Nonimmigrant Status, but many of our clients are willing to wait. They're saying, that's okay. I'm here as long as there's some interim, benefits in the middle. And we're going to talk about these interim benefits that do come in and when they're okay with it. And they're saying, okay, you know what, let's file this, because filing this at least gives me some modicum of protection to say, I've been here for this long. I've done this. I have a path to getting some kind of legal immigration status, so I'll do this. Okay, so even with this 10,000 cap and very long wait times. Our clients they want to do this, and this may be, again, their only path that they may have, or their only choice that they may have. The other con is that while this is pending, again, I'm telling you, these cases are pending for 8-9 years now at this point. And while this is pending, the non-immigrant or the person must remain in the United States. They cannot travel. There is no mechanism to ask for permission to travel. So if they do travel, it does have consequences. It can trigger other things, and we'll talk about that in a little bit as well, what certain actions may trigger for your clients if they do during the pendency of the application. And again, the pendency of this application is very, very long, 8 to 9 years at this point, okay? And then the other con is it is subject to policy changes. And the policy changes because immigration law sits within it's from the Department of Justice, and it sits within the executive branch. So depending on the administration and their priorities of how they want to enforce immigration or not enforce, and or what they want to do with it, it could change. So under the last administration, meaning the Biden administration, there was a policy for a victim-centered approach to removals and other kinds of enforcements. This current administration has it's like everybody's priority for enforcement. There's no more priority depending on if you're a criminal, if you're, how long you've been here. All of that is kind of gone away, and everybody has become a priority. So again, all that basically to say is that the executive branch really does control a lot of the policies for immigration law. And although immigration law is embedded in statute, it's done by Congress, etc., the implementation and enforcements are actually with the Department of Justice, and the Department of Homeland Security, which is within the executive branch. So this is why right now, this current administration's priority about enforcements and anti-immigration sentiment is very strong, whereas it was not necessarily that way for the previous administration.
We have a couple questions, if that's okay.
Yep.
This person asks, if a person gets on the waiting list, does
Mhm.
that mean that they are approved or likely will be approved and they're waiting to be approved as a part of that 10,000? Or does it mean that they're on the waiting list and could still be denied after the long wait?
So it's the latter. So they can be on the waiting list and they can be denied at the end of it all. When USCIS finally gets to their petition and looks at it, they may deny at the end, ultimately deny. So again, you apply, you're on this waiting list, you're pending. The one thing that is good about having at least applied for something, is that if you end up in immigration court or you're currently in immigration court, you can say, well, immigration judge, I have a remedy here. Not only do I have asylum that's pending or whatever other remedy that you may have put in, but I have this other remedy that USCIS, the Citizenship and Immigration Service, is pending in front of them. So please wait until that decision before you make your final decision about removability. So that is one thing that is a little bit of a protection while this application is pending, regardless of if it's ultimately denied and or approved. There's that like small layer if you are in immigration court and or if you get picked up by ICE for whatever reason. So a short answer is you're still pending. It does not mean that, you have a higher chance of getting this approved or not. You just apply, you're just pending. It's just pending in that 10,000 cap, right, time. But within that, I'm going to talk about this a little bit later. There's something called the bona fide determination, and we'll talk about that later. And this is when, during the pendency, different remedies that you may have, not remedies, but different what do you call it, that you may get. You can get, again, bona fide determination will give you a little bit of a more layer of protection as well. But again, it's not the final adjudication of an approval.
Got it. Thank you, Esther. And we have another question, but if this is going to be referenced later, please feel free to just note that. This person does ask, If someone is granted a U visa even with a criminal record, might they be eligible to adjust status even though they may not have been eligible to do so prior to being granted a U visa because of their criminal record?
Absolutely. And we're going to talk about that because that's why a lot of people, like the U tends to be very expansive in their waivers. And so if you can get that waived under the U, you may not have been able to get it waived under another immigration remedy. Say that you're trying to do it through a family-based, and because of your criminal record, you can't do it. Under the U, if you get that waived under the U, you can adjust under the U, and we'll talk about those, the waivers in a little bit as well, and why that is, the U is beneficial to many people who may not have other types of, a path. Okay,
Awesome.
so,
I just wanted to say thank you. Perfect.
Yep, no problem. Okay, so we're gonna talk now about the eligibility for a U non-immigrant status. For the principal petitioner, again, we're talking about the principal petitioner, the eligibility. We will bring in the derivatives a little later, but the derivatives is just a little bit different. Their eligibility is only that they have to be a qualifying derivative, and we're going to talk about that later on. But again, when I'm talking about eligibility for U non-immigrant status, we're talking here right now about the actual principal petitioner. And each of these things, 1 through 5, is one of the the eligibility criteria, and I'm going to go through each of them in detail, and I have case hypotheticals that we can walk through. So it is a victim of a qualifying criminal activity, possesses information about the criminal activity and helpful to law enforcement agency. The crime must have occurred in the US or violated US laws, and substantial physical or mental abuse, or as a result, no, it's actually sometimes substantial physical or mental abuse and or harm as a result of the qualifying crime, and the person can't be inadmissible, and that's where the criminal stuff comes in. It's number 5 here, and we'll talk about that in a minute. Okay, so what does it mean to be a victim of a qualifying criminal activity? So who is a victim? Is a direct victim is a person against whom the qualifying crime was perpetrated and who has suffered direct or proximate harm as a result. An indirect victim, so you can be a victim as an indirect victim or a direct victim. So the direct victim is the person against whom the qualifying criminal activity occurred, right? The actual person, or approximate, and they suffered direct and proximate harm. An indirect victim can be a family member that is helping to investigate or prosecute the qualifying crime. So for example, when we have indirect victim can be the mom or a parent of a direct victim. And the direct victim, because the direct victim is underage, under age 18, then the parent can step in as the indirect victim. We've had indirect victims because of for murder is one of them, actually, where a victim, a person may witness their family member getting murdered, or somebody that's close to them, they may have gotten murdered, and they see this and they're an indirect victim of that, right? Crime. Child sexual abuse, again, is something that we see a lot here in at her justice, and the parent is the person that's going to be the indirect victim of that direct crime of sexual assault or sexual abuse against a child. Okay. Any questions on who is a victim? Okay. So I'm gonna say, hang on, I'm looking at my notes here. Okay, and which family members can apply depends on the age of the direct victim at the time of the crime. And if the direct victim is 21 years or older, their spouse or unmarried children under 21 may apply as an indirect victim. if the victim is under 21, their spouse, unmarried children under 21, parents or unmarried siblings under age 18 may apply. This is a lot of stuff going on, right? So it depends on the age of the direct victim, the age of the indirect victim. And if you have questions about that, you should definitely talk to a practitioner that really does this work, because again, it's really nuanced in terms of who can be a victim, who can be an indirect victim, who can actually get the benefits of the U Nonimmigrant status. So again, but basically what you need to know is that a child in immigration parlance is anyone under the age of 21 and unmarried. Okay. Unmarried person under the age of 21 is considered a child if they, a biological child of a petitioner. Okay. Or if, again, the child is the one that is the direct victim and is the one that is going to be petitioning, then the derivatives can be their parents, okay, and siblings who are under age 18. So again, we're going to go a little bit more in depth into this in a little bit, but just so you know, direct victims, indirect victims, it all kind of is nuanced under depending on the age of the person and their relationship with the person. Okay. And what is a qualifying criminal activity? So we said, you have to be a victim of a qualifying criminal activity. The qualifying criminal activities are all under INA Section 101A 15U. This is again where the U visa comes in, right? And it talks about what the enumerated crimes include, but are not limited to those listed on this slide. Okay. But criminal activity must be analyzed under the statutory framework of where the crime occurred. For example, not all states have felony assault statutes, but you can argue the elements of the crime that are substantially similar to the elements of the enumerated crime. So again, you have to be looking, criminal law is state regulated, right? You're looking at the criminal activity, but criminal law is, again, done state to state. So each of the states have different they will have different definitions of what constitutes crime. So what you're going to look at is, hey, look at all these qualifying crimes, and let's see if something fits in to this rubric, right? Let's see if this qualifying crime and what happened in the state with the state criminal law, does it fit together to show that this was a qualifying crime under the immigration statute? Okay, does that make sense? It's a little bit nuanced. It's a little bit, I keep saying everything's nuanced because it is, but you do have to analyze it with the state statute and then looking at it as it is, as it pertains to what the immigration laws say in the INA. And here's this nice thing here in the red: any similar activity in violation of federal, state, or local law. It should be federal, state, or local law. So again, this is a nice catch-all phrase: any similar activity in violation. So you're going to be like, hey, this is a similar activity, right? Maybe there is no crime of domestic violence, but harassment, stalking, et cetera, all comes within the crime of domestic violence, what you would think of as domestic violence. So again, you put it together. Many states do not have actually enumerated a crime of domestic violence. They say stalking, harassment, assault, physical, whatever, this, that, and the other. And then you can put all of that together to say, this is what domestic violence is. Any questions on qualifying criminal activity? Okay.
We have one question, Esther. This person asks, when you say you need to analyze the state statute with federal law, does this mean that you need to do a categorical analysis like with crimes?
Yes and no. I mean, like usually we do the categorical analysis with crimes when you're trying to appeal something because they're saying, oh, well, this crime doesn't fit. And or if you're trying to appeal because they're saying and this comes actually more in the when you can't waive something, right? Here it's more on the approach of like, it's not as in-depth as a categorical approach that you're going to be looking at. It's more on this loosely fits in, right? Like what I was just saying about domestic violence. So when you're not looking at federal criminal statute, you're just looking at the INA here. So you're going to analyze the state criminal statute with the qualifying criminal activity that is enumerated in the Immigration Nationality Act. Does that make sense? So you're not looking at the federal criminal statutes necessarily. It's just looking at it from the qualifying criminal activity and the local criminal statute. I hope that answers the question. Because I mean, I don't really do a whole lot of I don't do actually any criminal immigration work. And so we don't really, the categorical approach doesn't apply here necessarily. It does apply later on when you're analyzing something for a waiver. But again, the U visa waivers are super expansive, and only when we're appealing a denial because they said it was, their discretion, do we go under do we start to argue the categorical approach? Any questions? Okay. So who is a victim of a qualifying criminal activity? Like I said, there's your direct victim and there's your indirect victim, and then there's a bystander victim. And you can try to say that somebody is a bystander. I talked a little bit more about the direct and indirect victim, and the bystander is somebody who witnesses a crime and who suffers unusually direct harm. Usually the bystander person is, I don't know how many of you in the audience are lawyers, but way back in tort law, we did learn about the eggshell head client who comes in and they had a prior pre-existing condition and something happens that exacerbates that pre-existing condition. Something like this, that kind of a scenario is where you're going to see the bystander victim. Somebody witnesses the crime, and because they witnessed it, they suffer unusually direct harm for that. It is hard to prove the bystander victim, but it is not impossible. But again, it is hard to prove that. You would have to get medical examination and reports about why this person has suffered direct harm because they witnessed something. Questions on the victim who is a victim of crime, qualifying criminal activity. Okay, we're going to go through a case scenario here. So I'm going to read you this. Hugo is a national of Guatemala. He entered the U.S. via the U.S.-Mexico border in 2019 when he was 19 years old. He lives in the Bronx with his 2 U.S. citizen children. One evening, as he is walking home, he is accosted by individuals who take his wallet and a gold chain he was wearing. Hugo reports a robbery to the police. Additionally, after this attack, Hugo now feels as if he is being followed anytime he goes out and is apprehensive about going anywhere. Hugo hears from a neighbor that if you are a victim of crime, you can file for a U visa. He comes to you and asks if he can file for a U visa. What do you think? Can Hugo file for a U non-immigrant visa? And if so, what is the qualifying crime? Okay, so you might think that robbery is the crime here, right? Because it was robbery. It was mugging, actually, like robbery. And so he reports the robbery to the police, and that's what they put it in as robbery. But robbery in and of itself is not a qualifying crime. Remember the qualifying crimes that we listed there? However, if it is coupled with a felonious assault, it qualifies, i.e. a weapon is used or if the person is beat up in the process. And again, this is why I said, look carefully at the criminal statutes in the jurisdiction to see if you can argue with the certifying agency to check off felony assaults, okay? And when I say certifying agency, we'll talk about that. You need to get, you have to show that there was cooperation. And so again, this is where we're saying, hey, on its face, it doesn't seem like Hugo has much of a U visa case. He doesn't have much of an argument to say there was a qualifying crime. However, see what he reported. Did he say he was injured? Does he have medical does he have medical reports to show that he went to the doctor, that they broke his nose, they actually used a gun, et cetera, et cetera. That use of a weapon, injury, things like this can go from just straight robbery to a felonious assault. So again, if it's a felonious assault, it can qualify as a crime that is enumerated in the statute. Okay. So again, it is really very important to look at the criminal statutes in the jurisdiction to see if you can argue that. If it, on its face, it doesn't have what you're looking for. Okay, now here's case number 2. Violetta is a national of Poland. She entered the US with a tourist visa in 2000 and has not left since. She currently rents a room from her mother's cousin in Queens. The cousin has been verbally and emotionally abusive to her. One night, the cousin punched her and threatened her after she confronted the cousin's habit of entering her room without her permission and taking her money. The police were called to their home and she reported the theft and abuse she endured from the cousin. The cousin was not arrested. Fearful for her safety, Violetta filed for an order of protection in family court against the cousin and obtained a temporary order. Can Violetta file for a U Nonimmigrant visa? And if so, what is the qualifying crime? Okay, in the interest of time, I'm going to keep going here. Domestic violence would be the qualifying crime here. Look at the DV statutes in the jurisdiction to see what constitutes a crime of domestic violence. Here in New York, Violetta will qualify because co-living and roommates and cousins also qualify as who can perpetrate domestic violence. If you are, harmed by somebody in that situation, you could say, hey, it's a crime of domestic violence. Okay. And so again, look, if it doesn't seem to fit quite squarely in what you were thinking as one of the enumerated criminal activities, see if you can fit it by looking at criminal statutes, family law statutes, et cetera, to see what fits and if it fits. And then the person has to, again, not only be a victim of the crime, they have to possess information about the criminal activity. And okay, obviously, if you're a victim of the crime, you are going to possess the information, which is kind of redundant, right? This part of the statute is a little bit redundant, but the second part here, and helpful to law enforcement agencies. So in order to be eligible for a U Nonimmigrant status, the victim or petitioner needs to report the qualifying crime to law enforcement agency. The important thing here is that second part here of this slide is helpful to law enforcement agency. And so what does that mean? They possess credible and reliable information, and they're helpful in the investigation. And you need to get, because you possess the information, you are helpful in the investigation or prosecution, and then you will request and receive an original and valid certification signed by the law enforcement agency. This number 3 here, this third block, is really is kind of the crux of a 918 or U Nonimmigrant Status Petition. You must have this last thing here, the original and valid certification signed by law enforcement. It's called the 918B. And if you do not have a 918B in your petition for your client, USCIS will deny, because this is one of the qualifying elements to actually apply for a U visa or U non-immigrant status. And the thing about the 918B, it is only valid for 6 months. So here, it is signed on May 7th, 2020. And that means your client's application must be filed before this expires, which is 6 months from May 7th. So it must arrive to USCIS by November 7th, 2020. Okay, so again, you have 6 months from the date this is signed. How do you get this law enforcement certification, you ask? right? You ask the law enforcement agency where the jurisdiction is from where the crime occurred. So the law enforcement agency may be, the law enforcement agency might be Department of Child Services, right? Here we call them ACS, which is Administration for Children's Services. We can get that for child abuse, child endangerment. And a lot of times when we see that there's child endangerment and the client says, well, there's also domestic violence, the ACS can and will sign that certification saying there was domestic violence in the household. Law enforcement can be police, can be the sheriff, can be family court. It can also be criminal court, the DA's offices. So they will sign as well. So again, if you do not practice in this area all the time, the Immigrant Center for Women and Children out in California, ICWIC, has a Zoho doc, and it's like kind of like a living document, actually, where people are always putting in law enforcement information, who you can ask for certifications, etc. Again, so if you do not practice in this area all the time, you just contact, others, like, I don't know, like other legal service organizations, immigration legal service organizations that do U visas in your area, to ask them, hey, like, can I ask you, who can I ask for a certification for, etc. Again, many law enforcement agencies or jurisdictions are in that Zoho doc that you can find on ICWIC's page. Again, it's Immigrant Center for Women and Children. They are based out in Los Angeles, or out in California, actually, but they do have a pretty nice document, kind of like a spreadsheet. It's searchable too. So you can do that, start there, and then move forward in terms of trying to find out who that law enforcement agency is. But again, this is so important, and it is absolutely necessary that you get this 918B certification from law enforcement. And this is why the client, your client, needs to continue to be helpful in that investigation and prosecute or the prosecution of that crime. Here in New York, if the client decides they're not going to move forward, they're going to stop cooperating. The law enforcement agencies may, and sometimes do, pull that certification saying, oh, we're not going to certify anymore. We're actually canceling that certification. So again, talk to other if you do not practice in this area all the time, talk to local practitioners that do this in your area about law enforcement certification and ways of how to get it. Questions on this? Okay. Okay, and then when we have the crime must have occurred in the US or violated the US laws. And again, this is pretty straightforward. Nothing really much to say about this one. It is that it occurred in the US or violated the US laws. And then the person's substantial physical or mental abuse and or harm caused by the qualifying crime. So whether abuse is substantial or whether the crime or the harm is substantial depends on the nature of the injury, severity of the conduct, severity, again, of the harm, duration of the harm, permanent serious harm to appearance, health, physical or mental soundness, totality of the abuse, and aggravation of pre-existing injury. Remember I said the eggshell head client person. So again, how do you evidence the substantial harm that has happened? These are the types of records that you can get, the types of evidence that you can gather. One thing that you are going to have, and we're going to talk about this in terms of what nuts and bolts of actually filing what you're going to file. It's this U1 principals petitioner's own sworn statement. So even if you don't have medical records, letters or affidavits, police reports beyond the qualifying criminal activity, right? Maybe the 918B certification. If you don't have anything else, the one thing that you really do need is this green slot here, the principal petitioner's own sworn statement. Basically, what happened to them, how do they feel, because of this crime, are they not able to, remember Hugo, he wasn't able to go out anymore, say that it is a qualifying, he is able to file for it, then one of the things he's going to say is, I'm so fearful of going outside. I'm so stressed out. Every time I go out, I'm always hyper vigilant. I cannot enjoy, just even taking a walk in the park, etc., because of what happened to me. So that's really important because your client's petition and the affidavit is going to go through each and every one of those the elements of the qualifications here that allows them to file for that U visa. I'm gonna keep going. I'm not gonna go through this case scenario because we are there's a lot to cover still, and we only have about 30 minutes left. So okay. I'm looking at this not inadmissible. This is where the criminal activity, remember that somebody asked earlier about history of crime and what happens if you have what happens about your immigration history, what happens if you have other things that have happened to you or you have done before you apply for this. So there's something called you cannot be inadmissible. Again, this last prong is worded as a double negative because federal immigration law contains grounds of inadmissibility, which can bar non-citizens from obtaining lawful immigration status. So basically not inadmissible. Inadmissible means like you have done something or there is something in your immigration history that makes it so that the US government does not want you here. You're inadmissible, meaning like, again, you should not be admitted into the United States. So this last prong here for the elements for qualifying for or eligibility for U Nonimmigrant status is that you cannot be inadmissible, okay? So when a non-citizen arrives at the US border or applies for lawful immigration status, they are seeking admission, right? They're seeking to be let into the US. So before they can be allowed in, the US government is going to look at what are these things that you may have done that makes you inadmissible. The admissibility thing here in the US, in the U context is kind of funky, right? Because the person is already here, right? They're not asking to be admitted at the border, but they are being asked to being admitted as a non-immigrant even while they are here. So they're changing from like maybe having no status to having at least a non-immigrant status that is recognized by the US government. And that's why it's called the U visa, right? You have some kind of visa status to be here, okay? Inadmissibility grounds are covered in INA, the Immigration Nationality Act, Section 212A. If you do have a chance to read it, I would say please read the INA Section 212A. Most of the common grounds that we find under 212A is present in the US without permission or parole. Many of our clients are in this section here. They live here because they're present in the US without permission or admission or parole, meaning they walked over the border and they are here. This is where everybody's like, oh, illegals. This is why people are saying, oh, they're illegal. Well, they are present in the US without permission or parole, admission or parole. Criminal convictions, somebody asked about criminal convictions, okay? Certain types of criminal convictions make it so that you are inadmissible. Crime involving moral turpitude, crimes involving moral turpitude. CIMT, that's what it's called. And most crimes involving moral turpitude, it's like theft crimes, things that make you morally turpitudinous, basically gambling, things that seem not so great, that the US government doesn't want you to come in. They don't want these types of people here. So again, depending on what crime it was. Felonious assault, aggravated felonies, things like this can make it so that those criminal convictions makes it that you cannot, you are inadmissible. Lack of a valid passport. So some of these things are very, very benign, it seems, right? A fraud or misrepresentation, a false claim to US citizenship, accrual of unlawful presence, meaning that you were here in the United States for a period of time without status. You leave and you come back, you leave, and then you've accrued unlawful presence. So then you cannot come back into the United States for a period of 3 years or 10 years, depending on how long it has been that you were here and then left. And then repeat immigration offenders, etc. So that's where like the inadmissibility grounds, there's so many of them under 212A. I'm going to keep going because, you guys, you can look at these case scenarios on your time, but again, I'm just going to move forward here because we're going to talk about how do you apply for this. Okay, so say that you do have an inadmissibility ground. Now you have to waive that inadmissibility. You have to say to the government, hey, I know these grounds exist against me, but now can I please waive these? Can you please excuse my behavior? So you're going to look at that inadmissibility analysis, check to see, does the ground apply under INA section 212A? And if so, can the ground actually be waived under the U statute? I said earlier, the U statute is super expansive on waivers. You can waive almost everything under the U. You can waive criminal things. You can waive false claim to U.S. citizenship. False claim to U.S. citizenship is an absolute inadmissibility, unwaivable under most other areas of immigration law. You can't ever get your green card from an employment based, family based, if you have actually made a false claim to U.S. citizenship. However, under the U statute, you can waive the false claim to U.S. citizenship. So again, but these are the ones that you cannot waive. Under the U, the one thing that you cannot waive is Nazi persecution, genocide, or commission of any act of torture or extrajudicial killing. Those are the things that you cannot waive under the U. Everything else you can waive. Nazi persecution was, again, many of our clients are not old enough to have actually participated in the Nazi genocide, Nazi persecution of World War II. However, if you are a current Nazi and this is happening, you might fall under this part. The other thing is for some of our clients that were fleeing, maybe they were part of like genocide because they were forced to be a part of that because there was unrest in their home country. They may fall under this, like, right, commission of any act of torture or extrajudicial killing. They may have been forced to be child soldiers, etc. Unfortunately, it's kind of unwaivable. Those things are unwaivable. You might try to argue that I was not of age, I was underage when these things happened, I was forced to do these things. But again, these are the things that cannot be waived even under the U statute. Everything else under the U statute can be waived. Okay. The waiver, if you need a waiver, it's going to be on form I-192. Okay. So again, you're going to have your I-918, which is the U petition, and then you're going to have the 192, which is the waiver petition, if your client presents with any kind of inadmissibility ground. Any questions so far?
We have a couple questions.
Mhm.
So the first one is the unlawful presence ground of inadmissibility, does that count as inadmissible for U visa applicants, or is that an exception?
Okay, so it does count as, so what you need to do is it depends. The unlawful presence is if you had been here and then you leave. Unlawful presence is triggered, and this is where it gets really wonky, is unlawful presence only gets triggered once somebody leaves. So if they've been here unlawfully present for, say, 10 years, never left, this ground does not apply. The only ground that may apply is that you came in over the border without admission or parole. But now the ground that may, but if they trigger unlawful presence and then come back, right? So you were here unlawfully present, you left, you didn't waive it, you come back in, and also over the border, then there is something called the permanent bar, permanent inadmissibility, and you have to waive that. So again, the INA 212A really like lays out what and how when things are triggered. And so if your client says, I came over the border, okay, that's one, right? That's one inadmissibility, which is present without permission or parole. And then they say, I left and I came back over the border, right? So then they have the unlawful presence and the permanent bar because they came back in without permission or parole. Okay,
Awesome.
so again, if your client, like, look at their history, really look into it, because many things can be waived. And this is the beauty of the U. This is why, even notwithstanding the 8, 9, 10-year wait that people have to do right now, this may be their only chance at actually getting their status to be a lawful permanent resident.
Thank you, Esther. And then I'll just give you one more question because I know we
Uh-huh.
are a little bit tight on time, but this person asks, if a waiver was obtained for U visa, then the same ground of inadmissibility may still be encountered when adjusting. If that is the case, do they need a new waiver?
So if it's been waived at the U visa stage, when you go to adjust your status, I actually do another webinar on just adjustment of status piece as well after you get the U, but you will already have your waiver. So you just show, hey, my this was waived at the U stage, so just continue this waiver on for me. You don't have to re-waive that at the adjustment of status stage. Once it's waived in the U, it should be waived at the U adjustment stage. However, USCIS can and have in the past, in my experience, have used their discretion to say, yeah, you waived it, but we want you to explain it more, and or we're going to deny you because it's our discretion to deny you because we just don't want people like your client here. And that has happened. And this is where you go and look at federal circuit court law, like, because some federal circuits say, no, actually we can look at this, and some say you can't. So again, this is where that kind of comes into play a little bit when you're asking for when you're appealing denials based on certain things here. Okay. Does that make sense?
Yes, thank you, Esther. And we can take the other questions later on. So go ahead.
Okay, so here's you're going to look at for when you're asking for the waiver, you're going to look at the considerations for the waiver. And it's like a balancing act, right? You're balancing the equities versus what it is that your client did that makes them inadmissible. And you're going to look at family and community ties, length of residence in the US, risk of harm to society and rehabilitation, the seriousness of criminal immigration or immigration violations. What was it? Was it just walking over the border? That's not so serious. Was it that you sexually assaulted a minor or you created a victim, right? That is one language that the USCIS has used in the past for some of our clients when we say, hey, can you waive this? And they're like, no, we're not going to waive this because your client's activities created a victim. Like they caused a felonious injury to somebody, you know, et cetera, et cetera. So that's like where you're going to look, and there's 3 R's, right? It's remorse, rehabilitation, and responsibility. When you're asking for waivers, you're going to say all these things. I'm so sorry this happened. I know it was wrong. I won't do it again. And this is what I have done to make amends. Okay. And again, the reasons for seeking admission to the US. I have a child who is a US citizen. If I had to leave, I'm going to, this child would suffer. I am a victim of a crime and I am getting all these services. And if I were to leave, this is where the extreme hardship to self or lawful permanent residents or US family members comes in. I don't get these services. You can move me back to Jamaica, and Jamaica doesn't have services for domestic violence victims. And or I am going to suffer more because my abuser got deported to or removed to home country, and they are there waiting for me, etc. So you're going to make your arguments of why they should approve the waiver. Again, it's the 3 R's, right? Remorse, responsibility, and rehabilitation is what you're going to do about the inadmissibility. Here again, what's the evidence that's going to support your inadmissibility waiver? The green is where you want to focus if you don't have anything else. Okay, if you don't have anything else, you want to focus on the green. The applicant's own sworn statement, again, describing the circumstances for the adverse factors and positive discretionary considerations that the USCIS should take into to account here. Okay, again, if you have documents showing, like if you have letters from the school PTA board saying, oh, this person has been such an amazing part of our PTA and is such an integral part of the child's learning and everything, right? She's a grandma in the community. She allows all the kids to come and stay at her house after school because the parents are working, etc. So you want to show all of these positive discretionary factors. This person volunteers in the church, comes to church every single Sunday, etc. Okay. However, don't have your client lie about things. I had a client that came in and said, oh, I go to church every day. And I was like, can you get me, or every Sunday, setting up things for the pastor? And I was like, can you get me a letter from the pastor? They're like, actually, no, because I really don't do that. So again, you don't want them to make things up, but see what your clients do have positive discretionary factors if you ask them. Okay. So again, just give them examples and then look at what their life is like and see if there are any that you can actually highlight for the inadmissibility waiver. Okay. So that is, in a nutshell, for the principal, applicant, and the eligibility factors and elements of a U visa and applying for it. Now we're going to go into qualifying family members. Again, what does it mean to be a qualifying family member? The qualifying family members are categorized as a U2, U3, U4, U5 derivatives, okay? The principal was a person that's actually applying for the U Nonimmigrant status, and then all these other people are U derivatives. So the qualifying family member, you have to be a qualifying family member to apply, and you can't be inadmissible. Again, if the child came in with mom and also crossed the border, the child would have an inadmissibility for being present without parole or permission or parole, right? Admission or parole. And they would also have to have a waiver. Okay, so it would be a 918A. That's the form for the derivative, and then it's and then the 192 is the inadmissibility waiver. You could have multiple inadmissibilities in one waiver, the 192. Okay, so just so you don't have to do like 3 192s because they have 3 inadmissibility grounds. So again, who is a qualifying family member? Under 21. If the principal petitioner is under 21, the qualifying family member can be a spouse, a child, parents, and unmarried siblings under the age of 18. That's where the U5 comes in. Very rarely do we see U5, but we do see them every once in a while. And then if the principal petitioner is 21 plus, most of our clients are 21 plus, it's the spouse of the person and or children, okay? And again, like I said, a child for immigration purposes is an unmarried person under 21. The thing about the U is that they keep changing certain things, certain qualifications. And again, they have allowed for after acquired spouses to be, you should be able to file for your after acquired spouse if the application is pending. Because this application is pending 8-9 years, people are putting their lives on hold, right? But say that, hey, I got married to somebody, I'm in year 5 of my pending application, and I want to now sponsor this person, or I want to add them to my U petition. You can do it. After acquired spouses are now allowed. It wasn't before, but now they are. Children, it cuts off though. The child has to be applied for at the time, before they turn 21, basically, okay? The child, you have to apply for your child before they turn 21. And even in notwithstanding how long this is pending or anything like that, the child has to be applied for before they turn 21. So eligibility for U Nonimmigrant status, qualifying family member, and not inadmissible, like I said. And that means the family member, the derivative person also needs that 192. So 918A is a petition for the derivative. And then you have 192 is going to be that waiver if they need it. This is really important. Tip cross-check form edition date against USCIS website. USCIS is notorious for constantly changing up their forms and the form edition date. If you look up here at the top, it says expires on this date. Do not look at this expiry date in terms of if it's valid to file. What you're going to look at is this thing here at the bottom left-hand corner of your form, and you're going to cross-check that with the USCIS website that says form edition date, right? And it will say which form edition they are receiving right now. If they say we will receive from this date on, that means you cannot do the older versions of that form. They overhauled a lot in January of this year because the gender question, there's a question on sex or like gender, and they took out gender and they put sex in, so it's male or female only at this time. It used to be you could be gender and non-binary was one of the answers, but that's no longer a choice, and now it is just male or female. And again, like I said, it just depends on the administration and who's in charge and what they want to emphasize. So forms may change because of what they're looking for or what they want to, at least on its face, right, have an emphasis on. So again, please, please, please make sure that you do get the right form edition date when you do file this. Okay. Joint representation, ethical considerations. Again, if you have done immigration law in the past, you know that this is a thing. There's going to be ethical considerations that you will need to look into when you are filing, because if you have derivatives, right, there may be a conflict down the line. What do you do? Who do you represent? So look at that when you're doing your retainers, when you're doing your engagement letters. Ethically, loyalty is owed to all clients and no duty to keep confidences between clients. So this happens a lot when the principal mom and maybe a child get into conflict later on because, you know, the child doesn't want to live with mom anymore, etc. And mom says, I don't want to do their petition anymore. I want to take them off my case, etc. So something to think about, that there may be some conflicts that may arise if you do have joint representation when you're looking at derivatives. Okay, so this is important. Look at this. I know you all know how to read. So this is where the contents of a U Nonimmigrant Status filing. So you're going to have a Form G28, which is your designation of you as the attorney and or a USCIS accredited representative. You're going to have your form, which is the Form 918, Form 192, if necessary, or for those that need that waiver. And then I-Form, I-1765 is the employment authorization document, and you could apply for that initially and ask for a deferred action. And we're going to talk about deferred action in a minute. But so this would be in your initial filing packet. This is for the principal petitioner. This is for the derivative petitioners, and this is what you're going to be looking at. This is going to be in your filing packet for the derivatives. Now, additional documents that are going to be in the filing, a cover letter. You're going to just kind of go through a little bit of basics. You're going to say, my client qualifies because they were a victim of a qualifying crime. They have the certification. Here's the, and we're sending in the evidence, not limited to, etc. And then you're going to list that out. You're going to have an index of evidence. Index of evidence is kind of important because it kind of gives USCIS a roadmap of what the evidence is that you are submitting for them. And then if any documents are in a foreign language, you're going to have an English translation of that document. Okay. So any questions on the nuts and bolts? Like the nuts and bolts are not as crazy. It's just, you know, just look at those slides again, what is necessary documentation wise that you would need to show. Now, timeline of filing and pre-filing. Step one, your case and client. You're going to look at that. Okay, I'm going to keep going because you all know your own how you're going to do the pre-filing, conducting the interviews, etc. Now, the kind of the post-filing is where a lot of practitioners that don't do this work have a lot of questions on, right? 1 to 2 months after filing, you should receive receipt notices for each application filed. Each application. So if you file the 918, you'll get a receipt notice for that. If you file the 192, you should get a receipt notice for that. If you file for employment authorization, you should get a notice for that. And once you get all of that, you're going to provide a copy to your client. 2 to 4 months after filing. Your client will be called in for biometrics, okay? And it's biometrics is a fancy word for fingerprints, eye scan, and it's done at an application support center, as ASC office, so you will get a notice for that. And once you get that, your client's gonna go, they're gonna get their fingerprints done, they're gonna get their eye scan done, and that's it. And then it's a whole lot of waiting. Lots and lots and lots of waiting. So after that, you don't hear anything. And then you're gonna go on the website and you're gonna check the receipt notice and the receipt number, and then to say case status check on those receipt numbers and receipt notices. And it will come up as an invalid number because there are privacy protections for the U filings. So the receipt numbers for U's and T's and certain applications do not show up on the USCIS case processing site. Okay, so don't be alarmed if you get the, there's nothing, okay? However, your case is not coming up. You could try the 765. The 765 may come up as being approved, as being received, and then you'll see it. It'll just say, oh, we sent you a notice, like a receipt notice, etc. Received it on this date. It won't say anything else. Now, if you go to the case processing times, not the individual case processing checks, but case processing times, if you see, and this is kind of a recent screenshot that we took, it's 59.5 months, okay? That's a really long time. And that is what they're estimating for the wait time for them to actually look at the case and say, okay, this is prima facie eligible for a U visa. Remember, I think earlier somebody had asked, hey, if I file it, does that mean that it's more likely than not that it will be approved? Actually, at the time of filing, you don't know that. At 5 years down the line, they do tell you you are prima facie eligible. On its face, it looks like you're okay. On its face, it looks like you are eligible to get your U. So therefore, we're going to put you on this wait list. You're going to have deferred action status. But because of the 10,000 cap, we can't give you the status right now, but we're going to give you deferred action, lower priority for removal, and we are going to give you your employment authorization document. This is why you pre-file that employment authorization document, right? The 765. So then they have everything and they said, okay, and your client can get the BFD and or the deferred action, and then they continue to be on this wait list, okay? Again, like I said, you can check the case processing times or case statuses of the 765 because that will show up, the U will not show up. The U3s, the 918As also will not show up, okay? And again, bona fide determination on its face, it's all good. And we're going to give you deferred action and employment authorization. It's good, but for the 10,000 cap, so we can't give it to you. Please wait, is what happens, okay? That is, in a nutshell, post-filing, right? So what might happen at the bona fide determination stage, though, right? Before they give you bona fide determination, they might say, you know what? We're gonna request for evidence. We don't have something from you. We need something more from you. So before they give you bona fide determination, they might give you an RFE and saying, hey, you know what, your 918B, the certification talks about, one we got recently was about child endangerment. Child endangerment is not domestic violence. So why are you saying it's domestic violence? And then we have to argue that, yes, it is because it's under this statute and it was related to this and it was criminal, etc. So again, they may ask for a request for further evidence to prove something that they're looking for. They meaning the USCIS, okay? And if you do that, then you may end up with the deferred action. And then the U1 principal is placed back in the queue for full adjudication. And it's like a first in, first out kind of a thing. So it will take a long time, right? So they're going to say, well, we have 100,000 people ahead of you. So we're going to look at 100,000 people before we get to you. But at least in the meantime, your client will have received her, again, benefits and limitations of deferred action. You get employment authorization, which is key to a lot of our clients, for a lot of our clients. They really, that's what they're looking for. They want valid work permit to be able to work here without any kind of repercussion, right? To be able to get their social security number. So again, employment authorization is key. Temporary protection from removal because they're deferred action. They're in the, it's like, hey, you're not really a priority. Even if you end up in immigration court, you can say, hey, you know what, judge, I have this remedy. My client has this remedy. We're just waiting. And then they get, again, your clients will qualify for public benefits and IDs. The bad things about deferred action, the NEAD, it needs to be renewed because it's not a permanent approval yet. It's temporary and it expires. So if it expires before the final approval, then your client will have to renew. And also deferred action and or bona fide determination does not give your client any benefit or ability to travel outside of the US. We're almost at the end. So again, approval notices are coming in 8 to 10 years after filing. And then once it comes in, you're going to look at the validity dates. It should be for 4 years. And approvals for any derivatives post-filing, if they are abroad and the child has, or the derivative is approved and they are not living in the US, they will need to do something called consular processing and actually enter the US with a U visa, okay? And it is done on Form DS-160. And this is where instead of working with USCIS, now you're going to be working with the State Department to get this visa. So this derivative person, child or spouse, can actually enter the United States, okay? After all that done is you're going to provide the client with a closing letter. These are just practice tips after approval that I'm not going to go through. I think we have 1 minute, but Nina, Q&A does not count for the 90 minutes, right?
Yeah, we have some extra time for Q&A, so
Okay.
feel free to go through the remaining slides and then we'll get to our questions.
Great. So here's some practice tips in terms of post-approval advice to your clients, right? They can adjust status, get their green card after 3 years of having U Nonimmigrant status, okay? But their U Nonimmigrant status is maxed out at 4 years. So between year 3 and year 4 is when they need to adjust their status and at least apply for their adjustment of status. The U adjustment of status is about taking a little over 2 years at this point, okay? So again, tell your clients to keep in mind the 3-year mark from when they get their U is actually approved, okay? And then they have to, when they are applying for their adjustment, they have to show that they have been continuously present in the United States for a period of at least 3 years. How do you prove this? Bills. You prove this with, I don't know, like utility bills, bank accounts, doctor's records, medical records, etc. Tax returns don't necessarily prove that you've been here for the whole 3 years. Tax returns prove that you were present in the United States on the day that you actually filed your taxes. That's about it, right? And that maybe you worked for the year, but it won't really show that you actually worked at your job. So pay stubs or the other thing that does show that you were physically present in the United States. So again, different things that you can look at for your clients if and when that time comes. And then limitations on travel may differ between family members, okay, 90, 100-day travel rule. If your client leaves while they have U status, they can trigger unlawful presence again, and then you will, this is between maybe year 1 and 4, right? 1 and 3, whatever. They then trigger it and you're going to have to talk about it again later on, okay? At their adjustment stage. So it's really, really, really important that your clients do not travel, or if they're going to travel, they ask for permission under filing a advanced parole application to travel. And people who have U Nonimmigrant status can apply for advanced parole to be able to have that permission to travel, so then you do not trigger the unlawful presence. Okay. USCIS tools and resources. Look at this. This is a really good page, and places where you can actually contact USCIS if you have issues with your client's case. The one that I really want to emphasize here are the NSC attorney email hotlines and the VSC attorney email hotlines, which is over here, right? I need a laser pointer, but anyways, right here. Okay. USCIS contact center may or may not be helpful to you because, again, there are confidentiality protections for the U visa, and they may or may not want to talk to you. They may say, no, we cannot give you any information because of the confidentiality protections. We need your client on the phone with you, etc. So a lot of times, I mean, for us, it's the attorney email and hotlines for both Nebraska Service Center and the Vermont Service Center has been the most effective. However, the hotline responses are taking 120 plus days for them to get back to us. So if it's actually like an emergency, you have to let them know this is an emergency. I cannot wait 120 days for you to get back to me. They do not like it if you're just inquiring about, hey, how much case processing, like what's the status of my case, especially if it is within their case processing timelines and you saw that it's like 6 years, like what, 59 months. So again, it's a very long time that you're going to be there. It's like 5 years before you can even actually ask them a question.
Awesome. Thank you so much, Esther. We can now go ahead and dive into the questions. Thank you for answering those throughout that we received. The first one that we have today is, can someone appeal the decision with a new administration? So if they get a denial and there's a new administration that comes in, say they're in removal proceedings, is it possible to appeal the decision under a new administration?
So the time to appeal a denial on a U or any USCIS decision is 33 days. And so you may not be able to wait for the new administration to appeal this decision. So you will need to appeal it almost immediately. And you can appeal it straight to USCIS or straight to the Administrative Appeals Office to say, okay, well, I want a motion to reopen and reconsider. There's more evidence here, and or a motion to reopen and just a motion to reopen because you did something wrong, right? So again, the decision was wrong for whatever reason. So again, the time to appeal is very limited. So you wouldn't be able to wait till the new administration for that, unfortunately.
And thank you for clarifying that, Esther. Our next question is, how would you bring your derivatives to the US if you have a pending U visa? What types of visa would they apply for, and what do they show at the consulate?
So unfortunately, and this is like a horrible thing, is that you can ask for something called humanitarian parole. If you have a pending U visa, you can ask for humanitarian parole under Form I-134. Okay, and what that is to say, hey, I have something pending, I can't go, but my child, my derivative person has to be here because of these circumstances. Okay, now, does it always work? Not always. It depends on the administration. During the Biden administration, they were approving these a little bit more. During the first Trump administration, we were getting these denied just all the time. It was almost like impossible to get a humanitarian parole application approved. I mean, some of the situations I could tell you, it's like the kids were getting abused, the kids were, it was just horrible circumstances. And USCIS routinely denied these, saying that we were trying to circumvent the immigration laws and that we had to wait. Under the Biden administration, once we showed like, hey, dire circumstances, nobody to take care of this child, mom's application is pending, child has to come here while that application is pending, we were a little bit more, we were more successful in those kinds of cases. So it just depends on the administration. It depends on the circumstances. It also depends on the adjudicator. Sometimes you might end up with somebody who's like, actually sympathetic and can say, oh, you know what, this does make sense that we give this person a humanitarian parole. So if your principal client has a pending case, they have children abroad, you could file the 918A. And a lot of times immigration will just say, you've got to wait that out. But you can try for the advanced parole or humanitarian parole to try to bring that child in. Other ways people have tried is trying to just get somebody a visitor's visa, right? Or a student visa. But again, then you end up with like fraud issues. Like, is it willful misrepresentation because you actually weren't going to be a student here? You weren't going to be a tourist here. You're actually going to come here to stay here. So you will run into those other inadmissibility issues as well. So it just depends. Yeah.
Thank you, Esther. And then this next person asks, for a principal petitioner living abroad who received a U visa approval but had a child during the waiting period, what would the course of action be for getting that child admitted along with the parent?
So the principal petitioner is living abroad and received a U visa. Then you would file an after, and the U visa was approved. This is an issue because and this is a debatable issue in terms of the child's age and the approval date. So the after acquired child application has been I believe as long as there's something nuanced about this one because it depends on if the U visa was approved prior to the child's application being filed. So, Kara, can you DM me later and then I can show you other guidance of what to look at to analyze your clients. Oh wait, who was it that asked that question? I'm sorry. Whoever asked that question, DM me and I will give you other places where you're gonna look at to do that a little bit more in-depth analysis.
Thank you, Esther. All right. So we have another question. This person asks if a person has a prior order of removal and is in withholding of removal only proceedings, does the U visa work as a form of relief instead?
Yes. Yes, they can. However, the U visa is not adjudicated in court. So what you're going to do is file for the U visa because they qualify. You're going to tell the court, hey, my client has this remedy. They filed for the U. Can you administratively close this? Can you take this off calendar? Can you, I don't know, like terminate proceedings while we wait, whatever. They rarely are they going to terminate proceedings, but they may agree to admin close while you wait for the U to be filed.
And thank you for that. And we do have about 8 more questions. Do you have time to take those, or would you like folks to contact you?
I can take those
Okay.
questions. As long as people want to stay on, it's fine.
Thank you, Esther. I appreciate that. This person asks, if an applicant made a false claim to U.S. citizenship that was waived through an approved I-92 and later obtained a green card, will that prior false claim negatively impact their eligibility for naturalization?
No, and that's where it's the beauty of the U is that the false claim to U.S. citizenship cannot be waived anywhere else but in the U, and because it was waived in the U, and that's the basis of their green card, they're fine getting that the naturalization later.
Awesome. Thank you, Esther. This next person asks, can an applicant work during the waiting period? If not, how can they remain in the country?
The applicant can work legally. They legally work during the waiting period if they get that employment authorization document, either with the bona fide determination or the deferred action. So legally, that is the only way they're able to work. How are they going to remain in the U.S.? Again, if there's any kind of enforcement action that is taken against them, they can show that, hey, I have, applied for this. Here's my receipt notices. I'm just waiting. But again, legally working is only with that employment authorization.
And thank you. And then this next person asks, if someone with a U visa application with an EAD is detained by ICE, what should they do?
Again, if they have a visa application or usually they won't, I hope, won't be automatically detained, but they should be able to show, this is why we tell our clients, carry around copies of receipt notices, copies of EADs, whatever you have to show that you have something pending, that you are in deferred action, you have something that authorizes your at least limited stay in the US, show that. So that I mean, obviously in this climate, it's really hard, like, right? Green card holders, people with withholding of removal are getting removed, and the US government is admitting to it being a mistake, but also not admitting to like how they're going to remedy that situation, right? So again, it is very, very important for anybody when they do encounter ICE that they are loud about what they have as a remedy right now, right? What they may have. They should also have all of their attorney's numbers in their back pocket to say, hey, look, I need to talk to my attorney. Okay.
Thank you, Esther. And this person asks, with a pending U application subject to a recent NOA, is a stay of removal appropriate?
You can ask for the stay. I would just ask for admin closure if you get that notice of appearance, a notice to appear. I mean, wait, NOA is NOA. It's not NTA. But you can ask for the stay. We have done that as well for our clients who are like, who have to have ICE check-ins. We've asked for stays based on pending U visas applications. We've asked for stays pending other applications. So again, you can ask for a stay. Again, they can say, well, it's just pending. They can wait for this approval outside the country, right? And that's an argument they have made in the past, they meaning ICE. So that is just something to be aware of, okay?
Awesome. Thank you, Esther. And last three questions here. So this person asks, does the employment authorization application have to be filed with the U visa application, or is that something that is automatically granted and offered?
Okay, so it is an automatic grant on the 918 form. It will say, do you want an employment authorization? So employment authorizations are under different categories. You get the employment authorization under A19 for the U, A20 if you're a U derivative. If you're under a bona fide determination or deferred action, it's C14. If you're going to get it under an adjustment of status, it's C9. So depending on the type of the employment authorization or what category it's under, you will check off the box and not file a separate one. But for derivatives, they do need to file a separate one. There is no checkbox to say, do you want one? And if you want that deferred action interim in between while your application is pending, you do need to file a separate employment authorization application under category C14.
Thank you for that information, Esther. And then we do have another question specifically about that second prong that you mentioned being helpful to law enforcement. For that specific prong, to prove it, do you need to produce an investigative report?
What you need to do to prove it is that 918B. That is the law enforcement certification. You don't necessarily need that investigative report saying that there was a domestic incident report or a police report that you filed something. But if you did do all that, hopefully, and if they investigated, they will give you the 918B. So you don't need the second part, but you absolutely need the 918B.
Thank you for clarifying. And then our final question for today, and thank you again for taking all of these. This person asked, if an applicant applies for the U visa but is removed via removal proceedings, will their U visa application continue? And does them being removed make the likelihood of the U visa being approved or denied more or less?
So if the person is removed because of, while it's pending, you will amend the I-192 to show that they have been removed. There was a removal proceeding against them and they have been removed from the United States because, again, inadmissibility. Prior removals can be considered an inadmissibility ground. You will, again, and depending on why they were removed, right? They may have triggered all these inadmissibilities. That's why they were removed. You're gonna, again, ask that those be waived. And you can amend that I-192 or make an amended I-192 even if the person is removed. So I don't want to say this because I hate putting things out into the universe. I have not heard of a U visa pending person being removed necessarily, right? But again, like I said, like they have been making arguments, like ICE has been making arguments the person can wait outside of the United States. So that is an argument they are making. I don't know how successful they are in that argument, but in that last question, I guess that would be the scenario if that they would get removed. But again, if they are removed, you can do whatever you need to do to waive whatever inadmissibility may have been triggered because of their removal.
Well, thank you so much, Esther, for answering all of those audience questions and sharing your expertise with us today. It's been wonderful to watch you present. And thank you all so much for submitting your questions. We really appreciate it. We want to thank you for joining us today for another Justia webinar. Before you go, don't forget that Justia Connect Pro gives you access to CLE credit opportunities through select live and on-demand webinars just like this one, helping you stay informed and meet your requirements. Plus, Pro members get an enhanced directory profile, AI-powered Justia chat to capture more leads through their profile, and a $200 credit on select Justia marketing solutions. Take advantage of these benefits by upgrading today and go to pro.justia.com. And have a wonderful rest of your day. Thank you so much.
Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please click the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next video.